Ready, start. This is aggrieved by exhibits P1, P2, and P4 proceedings of the second respondent for realization of income tax due from Center for Science and Technological Studies, Trivandrum. Proceedings were initiated against the petitioner under Section 226(3) of the Income Tax Act 1961 on the ground that a sum of rupees 11,073 is seen from the balance sheet of the said defaulter as given to the School of Engineering of which the petitioner is the proprietor. In reply to the Exhibit P1 and P2, the petitioner submitted Exhibit P3 reply stating that the amount of rupees 11,73,000 shown in the balance sheet of Center for Science and Technology Studies as on 31st March 1996 was given by the center as a grant and adjusted in the financial year 1996-1997, and as such no amount is outstanding as advance on March 31st, 1997. Along with the said communication, the petitioner had filed an affidavit also to the said effect. The second respondent, without affording any further opportunity, issued Exhibit P4 certificate under Section 222 and 223 of the Act, directing the petitioner to pay the sum of rupees 11,73,000. According to the authority, the said sum has become due from the petitioner on November 10, 1997 in the status of individual. It is against these orders the petitioner has come up in writ petition. The statement is filed on behalf of the respondents. It is stated that from the statement of accounts for the years 1991-1992 submitted by the Center for the Science and Technological Studies along with the returns claiming exemption from payments of income tax under Section 11 to 13 of the Income Tax Act 1961, it was noticed that the trustee had given periodical advances of rupees 11,70,000 up to March 31st, 1995 apart from grants. It is further stated that since the SSC had violated the provision of Section 13 in bracket 1C and 13 2A of the Act, claim for the exemption was rejected and a sum of rupees 12,59,000 was way of income tax and interest was raised for the said years. It is also stated that the petitioner is the president of the said SSC. It is also stated that the contention of the petitioner in Exhibit P3 objection was not accepted and he was treated as an SSC in default as per provision of Section 226(3) of the Act, and a recovery certificate was accordingly issued. It is further stated that the petitioner's request for the reconsideration of the same was rejected on November 26, 1997. It is stated that in the said communication it was specifically pointed out that the advance given to the School of Engineering has been accounted under the head loans and advances on the liabilities side of the balance sheet filed by the School of the Engineering as per the balance sheet as on March 31st, 1995. Para. I have heard learned counsel appearing for the petitioner and Sri N.R.K. Nair, learned standing counsel appearing for the respondents. The petitioner has been proceeded against under Section 226(3) of the Income Tax Act 1961 on the assumption that the petitioner owes money to the defaulter SSC and that the said assumption was on the basis of the balance sheet of the defaulter submitted along with the returns. It is noted in the said balance sheet that a total sum of rupees 11,70,000 is loans and advanced to the petitioner. But the case of the petitioner is that the said amount was adjusted towards grant and that no amount is due from the petitioner.